كلية الفقه الحنفي تقدم.
Bismillah ar-Rahman ar-Rahim. Alhamdulillah wa salatu wa salamu ala Rasulillah. So today we will talk regarding when a man divorces his wife in the death illness. So when a person is in his death illness, meaning that they are they're in an illness which they will in essence pass away from, but not necessarily a terminal illness or anything. The death illness is where a person is in essence on their deathbed. They're bedbound kind of thing, right? They are unable to stand up to go to the toilet, for example, or go fetch some water for themselves, or do their daily, needs. So when a person is in this death illness of theirs, from which they pass away, when they divorce their wife, what happens? If the person issues a revocable or irrevocable divorce, what is the ruling? What actually happens in this particular case? And will she inherit is the main thing we'll talk about. We will talk about the ruling here, because in essence he's trying to deprive her of inheriting her. So that is a major ruling. We call this the talaqul marid. Talaq of the marid, meaning the person who is in the maradul maut, not just the normal marid, not just the normal person who is ill. Then we will move on to the wordings a person uses, such as using insha'Allah, the mashiat of Allah, saying insha'Allah with divorce. So a person says, you are divorced, insha'Allah. What happens? What's the ruling? We'll do some rulings of exemption, and meaning a person that makes an exemption in a divorce. We'll talk about that as well. It's not a major ruling, but we'll just talk about that as it's in the book. And we'll also mention when a husband or wife becomes an owner of either their partner or a part of their partner. They become a shareholder, a stakeholder in that partner of theirs. Obviously that partner is a slave, that means. So this is previous to during the days when there were slaves. Obviously, just to understand the ruling, we will cover that very briefly, hopefully. Then lastly, we will also talk about, just to finish off the topic of divorce, we will talk about how divorce works in the West, especially in the UK, how the divorce works, the decree Nisi, moving on to the decree absolute. So what do these decrees mean when it comes to a Sharia aspect, concept, and what scholars say nowadays, because there's a difference of opinion among scholars. I will just tell you what the scholars mention and how they explain this ruling. So hopefully this should be enough for today. Bismillah ar-Rahman ar-Rahim. Alhamdulillah wa salatu wa salamu ala Rasulillah. So now the first mas'ala of today we're doing is regarding a man divorcing his wife during the state of his death illness. So if a person is in his death illness is where a person is just before death, in essence, where a person is on their deathbed, literally they are going to pass away soon. So now it doesn't have to be soon as in literally soon, but the idea is that it's the illness but in which a person is unable to carry out their normal needs. So for example, they can't use the toilet anymore, they're bedbound, they're in that death illness basically. So they're in their last state. Obviously sometimes a person could think that they are in the death illness, and then later on a person becomes well. So then afterwards, in hindsight, we know that was not the death illness. So then these rulings won't apply to that person. So this is specific to the person who is in the death illness. Now, sometimes some people do understand this to be some sort of terminal illness. This is not a terminal illness, okay? A person can be terminally ill, that can live for years. So that's not what this is talking about at all. This is in fact talking about a person who is in the death illness just before they pass away. The illness that they are in. Some people obviously don't fall ill at all, they just suddenly die. With a lot of people, it will be where they are ill before they pass away, and then eventually pass away in that particular illness. So the point is that illness, which sometimes lasts days, you would say as well, right? So for some people it lasts weeks. So that that death illness, when a man divorces his wife in that death illness, what happens? So the divorce will still take place because the man is sane, he's mature, he is liable for and is responsible for his actions. So that he is a mukallaf. So the idea is that his divorce will take place, and depends on which type of divorce he gives, then the subsequent rulings come into play. So if it mentions, if the man gives his wife a irrevocable divorce, and obviously he passes away in that illness, so if she is still in her waiting period, so obviously once he divorces her, she is now going to be in her waiting period. So while she is in her waiting period, if he passes away, then she will inherit him. Normally the case is, if a person is in a, just understand this first, I think, yeah, if a person is in a healthy state, normal healthy state, they're a normal person, and they divorce their wife, right? And a little while later, whilst the wife is in her waiting period now, he passes away, and he gave a irrevocable divorce to her, then she will not inherit. She will not inherit from him because she is no longer his wife. She's only doing the waiting period, right? So she will not inherit from him. She will continue finishing her waiting period off, and then that's it, it's finished. However, this particular case where a man is in his death illness and he tries to divorce his wife, he does it, in fact, he divorces his wife. A irrevocable divorce is quite important to understand this ruling here. Then what happens? First thing that happens is, obviously the divorce goes through. The first thing that happens is she will inherit him. She will inherit him. And what else will happen is her iddah, her waiting period that she was doing, will also change now. Because we're making her inherit him, so now what will happen is, in essence, what's happened is when he divorced her, she was in her waiting period of thalathata quru', 3 hayd cycles, 3 period cycles, and then after that she would have been, her waiting period would have been over, and she's out of that marriage completely. But when a husband dies, then the wife has to do, the widow in essence, has to do a 4-month, 10 days waiting period. So 4 months and 10 days. So now the point over here is to understand is that when the man has divorced his wife in this death illness, and as a result we're making her inherit him, she's going to inherit him. So the question arises, why is she inheriting him? So we say, okay, because she is kind of still the wife to a degree, because she's still doing a waiting period. So we're using that aspect over here, right? So then when it comes to the iddah, we'll also use that there and tell her that now you're going to have to do an iddah in consideration to the 4 months, 10 days. But the thing is, if the 4 months, 10 days finish before the 3 menstrual cycles, then she will continue with the 3 menstrual cycles. So that's a bit of a confusing mas'ala. What we call this is ab'adul ajalain. For those who prepare to understand, it's the further of the 2 waiting periods. So remember, she was already doing thalathata quru', she was doing 3 hayd cycles already. Meanwhile, he passed away. So she's going to be doing 4 months, 10 days too. So what that means is it's going to overlap each other. It's going to simultaneously continue. Whichever of them finishes first, it finished. So generally speaking, in a normal case, she's going to be the 3 haid cycles, the 3 menstrual cycles will finish quickly, will finish first, because it'll be 1 every month. So 1 cycle, 2nd cycle, and a 3rd cycle. But there will still be a month and 10 days or so left, the 4 months, 10 days. So she will have to obviously finish off the widow's waiting period. So that's what generally will happen. But if, for instance, let's use a hypothetical case to understand this, if a woman is having a menstrual cycle every 2 months, so once every 2 months, let's say every 60 days or so, she gets a menstrual cycle. So if she is like that, then remember her thalathat quru will effectively be 6 months. So 2 months for the first one, 2 months for the second one, 2 months for the third one, in terms of when they will come about. So her waiting period in total will roughly be around about 6 months, whereas her widow's waiting period will only be 4 months, 10 days. So if the divorce took place and she's now in her waiting period of thalathat quru, and more or less a day or so later he's passed away, so she's doing the 4 months, 10 days, and she's continuing the thalathat quru. If the 4 months, 10 days end here, right, that's the 4 months, 10 days finished here, but the thalathat quru hasn't ended yet, she will continue until that finishes. So the idea is whichever one of them finishes last, she will continue till then. The idea is that the reason is because the first waiting period she was doing this is a cautious mas'ala that we give out of caution, because we gave the first ruling because of the talaq, because of the divorce. For the thalathat quru would have been due because it's an irrevocable divorce, and but because we're making her inherit specifically, that's why now we're going to have to think that, maybe the 4 months, 10 days should apply now as well. So we're making them both apply, but they can continue simultaneously. Whichever finishes last, she will continue till there. So hopefully this makes sense. It's a bit of a complex mas'ala, but hopefully people can understand, and we'll summarize it at the end anyway. So this is what will happen. The idea is only if he passes away, while she is still in her waiting period when he divorced her. If she passes away, he passes away, should I say. If he passes away after she finishes the waiting period. So he divorced her, he is in his death illness, and he continues in his death illness. Meanwhile, her iddah finished. Her waiting period finished. Now, if he passes away, we can't make her inherit, because it's finished, right? The waiting period is finished. So she will only inherit during the waiting period. Normally, like I said to you, if a irrevocable divorce took place, then during the waiting period, the wife will not inherit. That's the normal case. But only an exceptional case for this particular ruling, where he is divorcing her in his death illness, we will make her inherit. The idea behind this, just to understand the concept, then I think it would be easier for people to understand. The idea behind this is that this wife, by divorcing her, he is trying to deprive her of inheriting from him. So he knows he's dying, he's in his death illness, so he divorces her, right? Why? Because so that she does not inherit me. She doesn't inherit him. That's what he's thinking. So Shariat, in essence, throws it back in his face, right? And says, you know what, take your, we're still going to make her inherit, right? But we can only do that during the waiting period. Beyond the waiting period, our hands are tied, right? We can't do anything about it. So because during the waiting period, there are certain aspects of the nikah still remaining, right? Namely in terms that she is doing the waiting period, she can't marry anyone until she finishes it. And why is she doing the waiting period? Because of his nikah. So likewise, he still owes her, accommodation while she's in the waiting period. He still owes her expenditure while she's in the waiting period. The food, shelter, and clothing is still owed by him. So all of these things still apply. So because these rights of marriage, though he's divorced her, still apply during the waiting period, we'll just add another one on. We'll tag along another one, which is inheritance. So she will inherit him too. So that's what we're doing. We're adding that one along because of his intent of trying to deprive her. So Shariat, prevents him from abusing in this way. But if it happened after the waiting period, like we said, then we can't really do anything about it, because we can't tag along the inheritance with anything, because there's nothing remaining between the two of them anymore. So hopefully this has made sense. Now moving on, I mentioned that this was regarding when the divorce is irrevocable. The reason being is if it was a revocable divorce, this wouldn't remain a speciality ruling. It would be even if the man was in a normal, healthy state and he revocably divorced his wife and then he passes away, she will inherit him. So it's no longer a special case anymore. The idea is she will inherit him anyway, as long as she is in a waiting period and then he passes away. So the speciality case only applies in a irrevocable divorce where we're still making her inherit, though the nikah has come to an end. Now, there are certain other exceptions to this where if she asked for divorce, right, or she did a khula or something, right, so she asked for divorce and he gave her the divorce, or he gave her a choice that you divorce if you want, and she exercised that right and she went ahead and divorced herself. So in all of these cases where she is the one who caused the separation, caused the divorce, then she won't inherit anymore, right? If he passes away, if it was in his death illness and she did this, and he passes away during the waiting period, she will not inherit him. Because obviously the idea here is simple, everyone can understand logically, that she voided her own right towards that inheritance. So then why should we, Sharia, bend over backwards in essence to try to look after her right? So we take that away from her, she will not inherit, it will just be like a normal case. And also, if he passed away, just in a normal case, so in the case where he divorced her in the death illness, a irrevocable divorce, and in essence during the waiting period he passed away, then she would inherit him. But if she passed away in this particular state before him, she passed away, then he will not inherit her, though she will inherit him, but he will not inherit her. The idea is because same concept, that he is the one who issued the divorce, so why would he inherit? He is not going to inherit her. So that is hopefully understood there. Now this same ruling applies to anywhere where there is a high chance of him dying, where there is no high chance of him dying. So for example, if a person was having a one-on-one duel to death, so this person was going to duel somebody and one of them are going to die in essence, right? Because you're dueling till death. Then because there's a high chance, because 50% is a high chance, one of you are going to die, right? There's 50-50. Then that will also come under the same category. If he is in that duel and then he divorces his wife irrevocably, she will inherit him if he dies there, and she's going to be in her waiting period. Likewise, if for example anything else that where there's a high chance of dying, so for example if a person was given a death penalty for whatever reason, they were given a death penalty, now they were put into their cell that tomorrow we will hang the person, or whatever it is that the death penalty was. So then what will happen to this person whilst they're in cell? Let's say they divorce their wife, the same thing will happen, because obviously the next day or whatever, next 2-3 days later, they're going to be given the death penalty, they're going to die. They gave divorce, though they're not ill, they're not terminal, or sorry, say they're not in their death illness, but they are now put forward to be killed, isn't it? That's the point. So the idea is that where there is a high chance of a person passing away, dying, this same ruling will apply if he divorces her in that state. Now, the next ruling here is if a man divorces his wife and says inshallah, so he says you are divorced inshallah, or he says inshallah you're divorced, and all of this is obviously together, he says it all in one sentence, then no talaq occurs. No talaq occurs. The idea of this is simply because whenever you say if, whenever you use the word if becomes a conditional sentence, right? So like if you talk to this person, you are divorced. So only if she talks to that person, then she's divorced, right? So if is a conditional sentence. So the idea of the translation of this is that you are divorced if Allah wills. If Allah wills it, then you are divorced. Now, obviously, this is not something that you can find out. It's not like you can go, knock on Allah's door or something and ask that, do you wish the divorce of this woman or something? It's unheard of. You can't do that, right? So because it's a suspension on the wish of Allah Ta'ala, and it's something you can't find out, that's why we can't issue a divorce. It's quite simple. No divorce can occur there. But like I said, it has to be, the inshallah has to be, in one sentence connected. It can't be like this. There can't be a pause in between. He can't say you are divorced if you wish. You are divorced if Allah wills. It's true, you've paused in between. That's not allowed, because you are divorced. That's already done. That bullet is already shot. So you have to say all in one go, you are divorced if Allah wills. I mean, you don't have to be like so quick about it. You are divorced if Allah wills. You don't have to be so quick to get it in there or something, right? All you have to do is say it connected. So you are divorced if Allah wills. But if you said you are divorced if Allah wills, or any time later than that, then it's too late. The you are divorced has already occurred because you paused in between. So that's the idea. Obviously, divorce is not something that we should be taking lightly, not something that we should be utilizing to scare. This is a very important ruling as well, that a lot of men, they use divorce as a scaremongering tool to try to make the wife comply to something, or to for whatever reason they use it as a scaremongering tool. So this is not the way Allah Ta'ala allowed the men to issue divorce. It's not there to misuse and to try to have some sort of power and authority over the wife by issuing or threatening even to issue a divorce in these kind of ways. So this is completely out is out of line. A person should not do this at all. So hopefully that is understood there. Next one is continuing with this topic of exemptions, because when you say inshallah, if you say you are divorced inshallah, this inshallah counts like an exemption. In Sharia, in fiqh, we call this a istithna. You have used something to exempt the divorce from taking place. In exactly the same way, if a person says, any other simple type of exemption, so like for example, let's say a person says that you are divorced 3 times except 2, or besides 2, then obviously 3 but 2 means 1. Or if a person says 3 but 1, then it's 2, because 2 are remaining, yeah? So obviously these kind of things, if you're divorced twice except 1. But you can't do, you are divorced 3 except 3, or 2 except the 2, 1 except 1. You can't do that. That cannot be done. I mean, you can't say something and exempt the whole thing. If you do that, the exemption doesn't count anymore. The whole thing applies. So that's something to be remembered as well. Obviously, it's not just a common thing that a person would do, but it's a mas'ala mentioned in the book next. Next, he mentions, if a person becomes an owner, obviously this would have been in the times where there would have been slaves, right? No slaves around now, but this is a concept here to understand, because there's a hadith, man malaka dha rahimin mahramin utiqa alayhi, a person who becomes owner of their relative, dhi raham, a womb relation tie, and you become owner of this person, then the person becomes freed. So let's say a person becomes an owner of their father somehow, right? They inherited or they bought, the father was a slave and was on sale, or mother was, or somebody like this, or brother or sister was on sale, and they bought that person, then automatically they will be freed. That freedom will appear. Now, the concept is, what about in the spouse? What about if you become owner of your spouse? Now, because this doesn't apply in the spouse, because the hadith mentions the womb relative, and your spouse is not your womb relation. So it's a spousal relation, obviously, kind of created through marriage. So when a person becomes owner of their spouse, so let's just say, use an example, if the man becomes owner of his wife by buying her, she was for sale in the market, for example, her master was selling her. So what will happen? The same applies if the other way around. If the wife was a free woman and she saw her husband, who's a slave, for sale in the market, and she bought him, right? Or she inherited him or something. She became owner of him. Or they became the owner of the full entire slave, they became owner of a part of that slave. So let's say 50% of the slave or 20% of the slave shareholding was up for sale. So they bought that 20% portion, or they inherited. They became owner of that portion, the idea is. So either you become owner of the full entire husband or wife, or a part of the husband or wife. The same ruling applies to all of this. What will happen? The nikah will break, right? The nikah will break straight away, but without talaq. Okay, without any talaq happening, the nikah will automatically, it will break. There will be no more nikah remaining between the two. Now, we understand the ruling. Obviously, it's not a ruling that applies nowadays, but the concept, like I said, I wanted to explain. So what's the concept behind this? Is that there is a conflict between the two different types of ownership, right? What we mean is that for example, when there's a husband and wife, they, for example, will share a child. Now that child is shared between the husband and wife in a 50-50 way, right? So this child, or you can say 100%, 100%, whichever way you want to count it. The idea is that this child is the father's equally as this child is the mother's. Yeah, both are attributed towards this child, or the child is attributed to this parents both equally. So you say, for example, you don't just say I'm my father's son or daughter, or my mother's son or daughter. You don't just say that. You are your father's not half son, half daughter. You are your father's son, your father's daughter, likewise your mother's son, mother's daughter, fully. So the attribution to the parent is full. So therefore we understand that the husband and wife, they have, like you can say, some degree of ownership, in essence, in owning that particular child, having that connection with that child in that way. Now, if we say that no, this husband and wife, one's the master, the other is the slave, right? Master and slave, because they were married and then he bought her and the marriage remained. If we do that, what happens is that the portion that this partner owns, who's a slave of the master, remember, because whatever the slave owns, the master owns. The portion that they own, the 50%, in essence, will be owned by the other partner. So the other partner will own their half as well as the other, their partner's half, which is their slave, right? So it'll be confusing. It's like two opposite rulings here, whereby on one side they're owner as well as they're owned, right? So you can't have a conflicting ruling in this way. So because there is a conflict between the two types of ownership, what happens? One of them have to cancel out. Either the slavery ownership between the two of them will cancel out, or either the nikah will cancel out. So now we analyze that which one should be cancelled. So if we say let's end the slavery, because that's what many people will think, that end the slavery, right? Because that's the better thing to do, end the slavery. Problem is, there's many problems. Just to give you a few highlights so you can understand and explore in your minds as well. There's so many others as well you can think of. We don't have time to go into every one of them. But the idea is that the slavery is something which cannot be regained. You can't just say, okay, let's reinitiate the slavery. I've freed you now, but let me reinitiate it. But nikah is, you can make up for that, right? Even if the nikah broke, all he'll have to do, or she'll have to do, is free that partner of yours, your ex-partner in essence now, the one that you become owner of, free them. Once you free them, obviously, now they will be even more appreciative towards you, isn't it? Even more love will create between the two of you, that you actually freed me, and now you're offering to marry me again, right? Whereas you could have kept me as a slave. So that's your love that is shown towards your partner that will bond you even more. Anyway, side points. The idea simply is, the fiqhi ruling here is that one can be made up for, the other one can't be. There's no make-up for if we freed. Likewise, another concept here is, if you follow a different angle, if you don't like that angle, is that in slavery, the person, the master, will own the entire person, right? There's full ownership. Whereas in nikah, there's only like partial ownership of privates, not anything else. So you can understand it from that angle. Other angles, there's many other angles to this. The idea simply is that when you are there's more benefit for you to be owning a slave than to be married to them, in essence, right? in a just a purely beneficial way. Obviously, in a moral understanding, from a moral stand, and from also from a love perspective, and all of the rest of it that we talked about, it would be better, in fact, to free. That's why we're giving you the opportunity to free and then marry. There's no harm with that, right? So hopefully people don't get bogged down with that, with this ruling. The idea of the ruling is that I wanted to explain that there is a conflict between the two ownerships. One is mastery, slavery mastery, and the other one spousal connection. Sorry, the spouse connection between the husband and wife. That connection and the connection of master and slave, there's a conflict between the two. So one of them will have to go, right? Because you can't keep both of them at the same time. It makes no sense. So one of them will have to go. And we see that there's more benefit in keeping the slavery. Why? We have explained why. So this is the concept as to why this particular ruling applies. I don't think we need to elaborate too much on this one. We've spent enough time on that particular ruling. I hope. Bismillah ar-Rahman ar-Rahim, alhamdulillah, wa salatu wa salam rasulillah. So now, before we move on to the next chapter, a modern ruling that we need to understand here is in the UK. We're talking about in generally the Western countries will have a system of divorce. I've explained previously that the divorce can only be issued by the husband. The husband is the only person that can issue a divorce. That's a concept from a Sharia perspective. Now, if the wife, using the law of the land, tries to issue a divorce, so she applies in court, and she, in essence, the court writes to the husband demanding a response, demanding a divorce, or an explanation as to why he isn't divorcing, which most of the times he won't be able to provide. So then she will push through a divorce. So according to majority of scholars, if it's instigated like by the wife in this manner, like it is, then the divorce according to Sharia will not count. The nikah will still be intact. Okay, there's many reasons behind this. That one is that the judge, in essence, will be a non-Muslim, and he is compelling a Muslim to give a divorce to his wife, which a non-Muslim judge cannot do. That's not in his discretion to be able to do according to Sharia. Obviously, law of the land is the law of the land. We're not, questioning, or we're not discussing the law of the land, whether that is correct or not, and the rest of it. That's not our forte. That's not what we're talking about here. We're talking about Islamically, Shar'an, according to Sharia, in the eyes of our Islamic rulings, will this divorce be valid Islamically, though it may be according to the law of the land. So that's what we're talking about here. So please do not misunderstand this. So the idea here is that it will not count as a Shari'i divorce. That's the reason why she will then go to a Sharia council and explain to the Sharia council, and then get her divorce through that means which we've previously talked about, how to go about doing that. So in this regard, we've understood if the wife is applying for a divorce. Now, if the husband applies for a divorce, then what happens? So according to a lot of scholars, so on this side, what we're talking about, majority of the scholars, the first ruling I gave you, will say that the divorce will not apply. Now, if the husband applied for a divorce in court, he applied for a divorce, whether it's a made up incident, like he's just making out that he's divorcing her, is actually not divorcing her, he's just doing it fake, or he's actually really applying for the divorce, right? A dissolvement of the marriage. So he's applying for this divorce. Then, according to quite a lot of scholars across the UK, especially, I can speak for, and generally across the Western world as well, the divorce will apply. The divorce will go through because the husband is the one who initiated, and then there's ways how they would consider that to be. They say that the husband, by initiating, he is giving authority to the judge, to the non-Muslim judge. He is making him his wakil, in essence, to issue a divorce to the wife. So this is what a lot of scholars have mentioned. However, there are scholars, and these are also big scholars in the West and Western countries. I'm not going to start mentioning scholars, but you can find online, there are many scholars as well, who say that the divorce actually does not occur. Even if the husband is the one who initiates, the divorce will not occur. The reason they say this is because primarily the main concept of this is that the constitution of nikah, the concept of what a nikah is, according to the law of the land, is different to what Shariat regards the nikah to be. So though we call them both marriage, they're both marriages, but what is marriage is different, understood to be different. So for example, you've prayed in the chapters of nikah. In a Shari nikah, there needs to be an ijab, there needs to be a qabul, meaning offer and an acceptance, there needs to be both in the past tense, there need to be two witnesses there, both male, and all of these conditions that need to be fulfilled. And if the conditions are not fulfilled, the nikah doesn't stand. Those same conditions don't apply in a marriage, in a law of the land marriage in essence, right? Although some laws have tried to incorporate certain things to try to make sure that, some people can't use and exploit a loophole. But the idea is that, let's just say, another wild example, a simple example, if two males wanted to do a nikah, in Sharia, it wouldn't stand, right? Even if they did the offer and acceptance, even if they did it in front of witnesses, even if they did it in the past tense, even if they did whatever they did, two males or two females just cannot marry. This just nikah will not stand. But that marriage will stand when it comes to the law of the land, right? If they, exchange vows and, they sign the right paperwork, they will be considered to be a married couple. So that means that the Western law considers marriage to be something different to what Islam considers it to be. So when this Western judge, in essence, is issuing a divorce, he is issuing a divorce to dissolve this marriage, the Western concept, not issuing a divorce to dissolve this nikah, the Islamic concept of what this contract is. Does that make sense? Though we're calling it both marriages, but this contract is something different to this contract, right? So when the judge is giving a divorce, he is dissolving this contract here, right? He's not dissolving this contract. That's the concept, basic concept, as to how these scholars mention that a divorce, even if initiated, should I say, by the husband, if he doesn't, verbally, if he doesn't write anything, or he doesn't verbally articulate any words of divorce or anything, the divorce will not go through. He has to still articulate, I have divorced my wife, or he has to write it, I divorce her name and whatever else. But if we look at the system, the way that, especially in the UK, I can speak for, because we've looked into the UK system, the way that it works. So the way it works is you first apply for a decree nisi. So you apply for a decree through, you can do it online, you can apply to a court that you want to apply for a decree nisi. It will be initial, temporary state, you would say, of a divorce. So what that means is, then the court will write to the husband for anything he wants to have time to try to give a response for, or to do whatever, right? So he's got chance now to give his side, in essence, or to either present a case or comply to what the wife is asking for. Or if the husband is doing it, then what the husband is asking for, the other side will be given this opportunity to say what they need to present, So during this period of a certain amount of, I can't remember exactly where it was, but it was a certain amount of period where this decree nisi will continue for. After this time period is over, once the decree nisi time is elapsed, then whoever's applied for the divorce, they can now apply for a decree absolute. So now you apply for a decree absolute, the court will see and they will judge using all the paperwork that they have there, then they will issue a decree absolute. Now when they obviously carry out the decree absolute, what I've seen in many letters, and you can see this. We've had a chance to ask for people that have gone through the system for their paperwork. I've not seen myself, the wording of divorce being used by the judge. So the judge doesn't say that I issue a divorce on behalf of the husband or anything like that, any wording of divorce. More so, the wording is used as dissolving, not even a marriage. The marriage wasn't even being used in some of the paperwork that we saw. So it just depends on the way that is being issued to. That needs to be looked at. The wording needs to be looked at. How the judge, what is the judge saying? What is the judge doing? Right? So these concepts need to be understood. So I think if we can have a detailed understanding of this from what I've just explained, hopefully people understand that the idea behind a court divorce, because there's scholars that do have a point here, but there are scholars on the other side who say that if the male initiates, then it should be done, right? So both sides have got a point, you can say. Personally, I would sway more towards this side because in terms of that it wouldn't issue anyway, but that's down to a person. If you study this properly and you understand it properly. The reason why is simply because there's a way out here, which is to, if he's the one who's issuing and initiating that divorce, then tell him to verbally just say it too. It's not hard. Verbally just say that I divorced my wife. What are you applying for? I'm applying for a divorce. I've divorced her, right? So whatever it is, the idea is that it's not that hard, especially if he's the one. So practically speaking, it doesn't make such a big deal to make everybody satisfied. All the scholars will then be satisfied that, yeah, actually, you know what, this divorce has gone through because he verbally said it, even though he's also applied for it, but he has also said it. So then everyone will say that his divorce is done. Hopefully, this gives us a understanding of the way that the divorce works in courts. Bismillah ar-Rahman ar-Rahim, alhamdulillah, wa salatu wa salamu ala rasulillah. So today, alhamdulillah, we have done the ruling of the talaqul marid, the divorce of this person in their death illness. So we talked about the details of that if a person, before that we discussed, we should be, just to go in sequence, if a person divorces their wife, in a normal healthy state, then she doesn't inherit him, even if she is in the waiting period. The only time she does inherit him is if he gave her a revocable divorce and she is in a waiting period. Then she'll inherit him because practically they're still husband and wife. So she will still inherit him. Likewise, the waiting period for her will also transfer to the Abadul Ajalain, the further one that we talked about for this particular woman. That's in a healthy state, right? So that's a completely, understood mas'ala, a very simple, easy mas'ala. Now, in the marad al-maut, death illness, the person divorces his wife. If it was a revocable, the same ruling would have applied anyway. But this time, when it's an irrevocable, we also apply the same ruling here, meaning she will inherit. That's the main ruling here, that she will inherit. Her iddah obviously transfers as well. But main thing is that she will inherit because he's trying to deprive her of inheritance, which we will not allow him to do. So during the waiting period, she will inherit him if he passes away during that time. If obviously he passes away after, then she can't inherit him. There's nothing we can do about that. So that's the first ruling we prayed in detail. Then we mentioned a little about if a person was to say inshallah connected to the sentence that he says, he says you are divorced or I have divorced you, anything like that, and connected to that straight away without any pause, without breaking, he says inshallah, then nothing happens. We talked about exemptions as well, and we talked about when a person becomes owner of their spouse, their husband or their wife, what happens there. So I think that was easy. And then we went through the different opinions of scholars regarding the modern divorce, the way that it happens in courts. So we went through, if the wife initiates, then majority of the scholars will say that that's not a shar'i divorce, though legally that's a divorce. Shar'i won't be divorce. and according to a few more scholars now, so that when the husband initiates, there you have a few more scholars saying that it will issue, whereas other scholars say that it will not issue. So you got this difference of opinion. I've explained it enough for people to be able to understand this. When a person, another point to remember here as well, when a woman is applying for a divorce through a Sharia council, they will tell her to, if they are married according to the country, according to the law, they will tell her to do to get the court divorce first. So they will ask her, have you done your decree absolute? Meaning, have you got your decree absolute? Yeah. So she has to go through doing that decree nisi, decree absolute, and thereafter present that to the Sharia council, who will then issue, will conduct their affairs, will conduct what they need to do. Otherwise, generally speaking, the Sharia council won't tread over toes of the legal law of the land and give a divorce according to Sharia when, according to the law, they're still married, right? So they will tell her, or they will tell the husband and wife, to go and get their their legal marriage dissolved first and then come. So this is just the point to know. Most Sharia councils would work like that. That's the summary.